Quite a few people in the comments section, both here and on my Black Belt Barrister videos, are curious as to whether Prince Harry has any shot at appealing this decision with regard to his private security when he visits the UK. Now, I've done a longer video on this over on Black Belt Barrister, but I realise that you guys here, some of you only watch Black Belt Secrets and have no idea about my other channel, but I'll link that in the description below. You can subscribe there if you would, please. And if you would like to subscribe here too, if you'd like my views, my more free-flowing views that you don't really get over on Black Belt Barrister, I'd really appreciate that. And thank you for subscribing on the last video. They really bumped the subscribers, so thank you for that. So in short, there is no automatic right for him to appeal this decision. In fact, a lot of people are surprised to learn that there is no automatic right in most cases in the United Kingdom. There are very few. Now, some of them, such as decisions for habeas corpus being held in contempt of court, and also trials that are heard in the Magistrates' court, so they are tried summarily. But I'll come back to those in a moment. Let's speak about this Harry case first. So, as I explained in my Black Belt Barrister video, he will first need permission to appeal, because there is no automatic right to appeal this decision. So one thing that does sort of irritate me a little bit, although they do simplify it for a reason, but one thing that does irritate me a little bit is all the headlines say that Harry is appealing this decision, which is not entirely accurate, because that suggests to a casual reader that the appeal is live, it's going forward, he is appealing the decision. But that's not the whole of the story, because before you can appeal the decision, you need permission to appeal the decision. It's not as though you just walk out of court and say, right, well, I'm appealing this, and you go off to appeal. It's not quite that straightforward in the United Kingdom. There are two ways of obtaining permission to appeal. You either get it from the judge that heard the original case, which, as you can imagine, is probably quite difficult because the judge has just heard the case, and in most circumstances is unlikely to then say, well, yes, okay, I think my decision might be wrong, therefore you can appeal it. Now, in some cases that might be the case, but only usually where there's a principle of law or some other procedural irregularity that the judge is aware of, and the judge might say, there's a possibility here that this might be appealable. Or where there is a particular question of law to which the judge says, well, my ruling on it is this, but it is entirely possible that there is another interpretation. Therefore, yes, fine, I'll give you permission to appeal this decision. And the judge might then give leave or permission to appeal the decision. However, that's not usually the case. The judge hearing the case first instance is usually going to refuse permission to appeal. I've had an opponent litigant in person before now say, well, I will appeal. And the judge said, no, you won't, because I'm not giving you permission. And then he did then seek permission, which is the second way of seeking permission. He did seek permission to appeal by filing it to the appeal court, which is within the county court will be a higher judge, so a circuit judge instead of a district judge, or from the county court to the high court, or from the high court to the court of appeal. And so you file that application it's an appeal notice, you seek permission to appeal, and that is then initially decided on the papers, and then all but the court of appeal requests can then be renewed by way of an oral hearing. But for the Court of Appeal, it's slightly different. And in all of those cases, there needs to be, at the very least, a real prospect that the appeal is going to succeed, or some other good reason, compelling reason, that the appeal should be heard. And it needs to be a compelling reason, not just, well, we didn't like the decision, and other people might not like the decision, therefore we should be able to appeal it. That is not a compelling reason. A compelling reason might be a significant public interest, it might be a complex area of law and a question of law that really does need to be addressed by way of appeal, and it's not safe to leave that as it is because there is a question over the law, even though the judge may have made a ruling on that particular law at that time. But either way, there needs to be a compelling reason or a real prospect that the appeal is going to succeed. And ordinarily, there would need to be something along the lines of fresh evidence that could not, with reasonable diligence, have been obtained the first time round. So if you don't have anything like that, there is no point of law that is in question, there's no procedural error that is in question, which is highly unlikely given that this was a high-profile case in the High Court. There is almost no chance of permission to appeal in cases like that. And even if you do get permission to appeal, which I don't think Harry will, and it goes to appeal, then it's unlikely to succeed in the vast majority of cases, because in the vast majority of cases they've been heard properly the first time round. And there is almost next to no chance of appealing a case based on a finding of fact by the judge at first instance. And even when there is a question of law and the interpretation of law, there are far fewer cases that go to appeal, and even fewer that are successful than go through the run-of-the-mill court in the first instance. And so when an appeal is heard, if the appeal fails, there is a second appeal opportunity, but again you need permission, and there is the test for second appeals, which is even more stringent than the first, because the same bit of the test applies at the outset, in that there must be a real prospect of success, in that it raises a point of law, procedure, evidence, and so on. But then there is the conjunctive and must raise an important principle of law, or principle or practice, or some other compelling reason for the court to hear it. And so ultimately, to reiterate my prediction, I don't think he'll get permission, and even if he does, I don't think it'll be successful. And I appear not to be the only one to think so. There are other experts quoted in the news that have said so, and my learned friend Alan Robertshaw over on Art of Law, yes it rhymes, linked in the description below, also thinks the same. So we're all prepared to stand and be corrected if that's not the case, but I would hazard my best guess on that being the case. I think he'll be refused at the permission stage. But as I said, coming back, there are certain cases like trials at the Magistrates' Court, because they are before a lay bench, or at least the vast majority are before a lay bench, as in magistrates. They are directed on the law by the advisor, but otherwise they are justices of the peace. And they hear trials which are either summary only, which means they stay in the Magistrates' Court, or a trial or an offence which is either way, which happens to be heard in the Magistrates' Court because the Magistrates' Court accepts jurisdiction to hear it in the Magistrates' Court, and the defendant does not elect a Crown Court trial. So if it's an either way, then the Magistrates' Court could say that we are keeping it, but the defendant might say, no you're not, I'm going to the Crown Court, I want a jury. That's called electing the Crown Court trial. And obviously for summary only cases, they cannot do that. It stays in the Magistrates' Court. But what they can do is appeal any conviction and or sentence to the Crown Court. And that is then done by way of a rehearing. And that will be with a fully qualified Crown Court judge and 2 magistrates. Now, one school of thought is that the judge will know that you're coming to the Crown Court having been convicted in the Magistrates' Court. Not that that should make a difference, but some people seem to think it does. But it's also without a jury, so it isn't the same as having a trial in the Crown Court in the first instance, because obviously you have a jury and you must persuade either way the jury whether you're guilty or not guilty. But with an appeal to the Crown Court, it is different. But it is an automatic right of appeal, a conviction and or sentence from the Magistrates' Court. And there are various other rules as well. On the other hand, if you wanted to appeal a conviction or sentence from the Crown Court, then again you need permission, because as I say, apart from those very few cases, including trials in the Magistrates' Court, there's no automatic right to appeal a court finding. So I hope you found that interesting. I hope you find my prediction interesting. But either way, we will have to wait and see. But in the meantime, you can hit that like button, you can subscribe, and I can thank you for watching.